Hello, good day. Welcome once again to another episode of Kwentuhan sessions. For this episode, we'll be discussing Engineer Alex C. Baguio versus Commission on Audit, GR number 223547, April 27, 2021. This is a civil law case discussing somehow solution indemnity and unjust enrichment. This is also part of the COA cases. Okay, for the facts of this case, Engineer Pagio, along with other petitioners, are officers and board members of Pagsanhan Water District or PAGWAD. PAGWAD is a government-owned and controlled corporation under the Presidential Decree number 198, known as Provincial Water Utilities Act of 1973, as amended. In 2009 and 2010, the PAGWAD board members received several benefits, which included year-end financial assistance, medical allowance, and anniversary bonus, productivity enhancement incentive, and communication allowance. So, diba, tiba-tiba sila dito ng mga allowance. On May 10, 2012, notice of this allowance number 2012-100-001 was issued disallowing the above enumerated disbursement with an aggregate amount of 283,965 for lack of legal basis. So, yung notice of disallowance, of course, came from an audit coming from the Commission on Audit, that it was found that the benefits were given to the board members without approval from the Local Water Utilities Administration or LW UA in violation of Section 13 of PD number 198 as amended, COA Resolution 2004-006, and Department of Budget and Management Regulations. Petitioners were made liable to settle the disallowed transactions. Petitioners appealed the notice of disallowances to COA Regional Office 4A and COA proper, where they argued that the Board of Directors is authorized to prescribe additional allowances and benefits to its members under Section 13 of PD 198 as amended by RA 9286. Moreover, they claimed that the grant of year-end financial assistance was based on LWUA Board of Trustees Resolution number 239. The appeal was denied, hence this petition. So, ayun, this is one of many disallowance cases, and also this was decided by the Supreme Court en banc pala. Of course, just penned by Justice Mario V. Lopez. So, yun nga, as an all of the of any disallowance cases na marami din na under Justice Mario V. Lopez. Here, it was found that a disbursement was illegal, okay, and was not authorized. And here, Engineer Pagio and the other members of the board are assailing the legality. So, sabi nila, tigal naman yung mga allowance na binigay nila sa sarili nila, 'di ba? Yun yung gusto nilang sabihin. Sana all, 'di ba? So, let's go to the issues. Whether or not petitioners timely filed their appeal to the Supreme Court. That's issue number 1. Issue number 2, whether or not COA or COA, gravely abused their discretion in disallowing the benefits and allowances enjoyed by the petitioners. And number 3, whether or not the petitioners are liable to refund the amount being disallowed by COA. Okay? So for the first ruling, the Supreme Court en banc and through Justice Mario V. Lopez said that no, the petitioners did not timely file their appeal to the Supreme Court. Okay, so it was not timely filed. The 2009 revised rules of procedures of the COA prescribe a period of 6 months or 180 days from receipt of the notice of disallowance to appeal an auditor's decision to the regional director up to the COA proper. So once you have procedure is once you have received the notice of disallowance, okay, the 180 days prescription starts. Okay, so from for you to appeal to the regional director up to the COA. So tuloy-tuloy yung bilang ng araw nun. Petitioners admit their appeal before the COA proper was filed beyond the reglementary period. So, aminado naman silang late sila. They received the notice of disallowance on May 23, 2012 and filed their appeal on November 14, 2012 or 175 days. Okay? So, yung appeal nila to COA Regional Office 4A spent 175 days. 180 days lang yung pwede. Okay? Kasama na yung pag-appeal mo sa COA proper. Okay? Thus, they received the COA 4A decision on April 23, 2014. Thus, they have the remaining 5 days of the 180-day period from April 23 to April 28 to file an appeal. Without any explanation, however, they filed their petition on April 30, which is 2 days late. Okay, so tuloy-tuloy yung prescription. Nag-stop lang nung nag-appeal sila sa um, COA 4A, Regional Office 4A, pero tuloy-tuloy yung bilang. Okay, so mula dun sa 175 days, they have only 5 days to appeal the decision from the COA 4A denying their appeal para iakyat sa COA proper. However, yun nga, late sila ng 2 days. Petitioners, however, entreat this court to exercise leniency in the application of procedural rules and to resolve the case on the merits. Time and again, we have been reminded that procedural rules should be treated with utmost respect and due regard because they are precisely designed to effectively facilitate the administration of justice. Justice Mario P. Lopez said, "For this reason, we have always taken precaution in exercising such liberality as we may do so only for the most compelling reasons when stubborn obedience to the procedures would defeat rather than serve the ends of justice. To rule otherwise would trivialize the time-honored principles of adherence to procedural rules. It is essential, thus, that every plea for court's exercise of liberality should be accompanied with justification that speaks of strong substantial justice consideration. Here, there is no compelling reason to relax the rules. For one, petitioners did not give any explanation as to why they failed to comply with the procedural rules. Also, they merely harp on the grievous effects of the COA's adverse decision to their families, considering their meager income and personal loans. To be sure, general averments of social justice concept would not suffice to warrant deviation from the established rules and principles on immutability of judgment of final judgment as every litigant can conveniently allege injustice from every adverse decision. So here, Justice Mario V. Lopez did not give the petitioners leniency, okay, in or the liberality uh, in uh, in applying the rules. Okay? So, yun. Dahil, ayan, matigas ulo nyo, hindi kayo marunong magbilang ng 180 days, ayan, hindi kayo pinagbigyan. So, yun lang naman yung sa issue number 1. So, issue number 2, no, COA did not gravely abuse their discretion in disallowing the benefits and allowances enjoyed by the petitioners. As we can recall, so these are the year-end allowances and other allowances such as financial assistance, medical allowance, anniversary bonus given to themselves. Okay, so nagpakasasa sila sa sarili lang allowance dahil sila yung board. Sabi nila, magbibigay tayo ng allowance sa ating sarili. Okay, dahil akala nila, okay, petitioners argue that the board of directors derive its authority to grant additional allowances to its members from Section 13 of PD 198 as amended by RA 9286, then cite the following LWUA issuances to support their claims that the grants of the questioned additional allowances to the PAGWAD board members were with LWA approval. Okay? Indeed, Section 13 authorized the Board of Directors to prescribe additional allowances to its members, said Justice Mario B. Lopez. However, the Board of Directors does not have unbridled power to grant additional allowances for themselves, as Section 13 explicitly requires LWUA's approvals for such grant. So, hindi basta-basta. Kailangan magpaalam ka muna sa LWUA. Okay? On this score, we agreed with the COA and that PAGWAD Board of Directors did not comply with the required LWUA approval. We cannot sympathize with the petitioner's argument that the cited LWUA issuance legitimize the grant of the challenge benefits given to PAGWAD board members. Okay? So, just to give you context, ano ba tong local water districts na to? 'Di ba, kung merong NAWASA, merong MWSS, dito sa city, sa mga province naman, merong mga kanya-kanyang mga water concessionaires na ang may hawak ay ang gobyerno. Okay? So, yung mga provincial water districts. Okay? So, within, they are considered GOCCs and within the powers of the ambit of the powers of the president. Okay? So these issuances cannot be considered as legitimate pertaining to the LWA issuances being argued by the PAGWAD board for the year-end financial assistance and cash gift because in 2004 or more than a year before the issuance of the LWUA Resolution number 239 in 2005, Administrative Order number 103 was already in effect, expressly suspending the grant of new and additional benefits to all GOCCs and employees to implement austerity measures in the government. So, ang sinasabi dito ng court is that dapat alam nyo na pinagbabawalan kayong magbigay ng allowances kasi nga nagbigay naman ng order, ng administrative order a year before you made your own orders, okay, giving you the allowances. Okay, to be sure, the LWA Board of Trustees as well as the Water District Board Directors cannot ignore this clear directive from the Chief Executive that applies to national government, its agency and instrumentalities, as well as to all GOCCs, government financial institutions, and other government corporate entities. Otherwise, they will undermine the President's constitutionally vested power of control and supervision over all executive department, bureaus, and offices, which includes GOCCs such as the LWUA and local water districts. So, as mentioned, under sila ng President. Simply put, petitioners and the LWUA erred in granting the approving the year-end financial assistance and cash gift to water district board members at it patently contravened with the AO or Administrative Order 103. In sum, the COA proper did not gravely abuse its discretion in upholding the disallowance of all the additional benefits and allowances given to the PAGWAD board members for lack of legal basis. So, yun. Dahil pinagbawalan naman kayo pero matigas ang ulo nyo. Kaya, yun. Disallowed yung disbursement and in ruling number 3, the court said, yes, the petitioners are liable to refund the amount being disallowed by COA. Okay? Since matigas ang ulo nyo, ibalik nyo yung pera ng gobyerno na pinaghirapan ng mamamayan. Okay? So, yun. It is well settled in our jurisdiction that a judgment that lapses into finality becomes immutable and unalterable. So, given na the appeal was made too late, 2 days late, it became final and executory. So, dahil nga dun sa issue number 1, sinabi na final and executory na to, wala na dapat actually pinag-uusapan. Okay? Consequently, a discussion on petitioner's alleged good faith is rendered immaterial. As approving and certifying officers of the disallowed benefits, petitioners are liable to settle the unauthorized disbursement consistent with our ruling in Madera versus Commission on Audit, wherein we clarify the extent of liability of the participants in this allowed transaction. So again, this Madera versus Commission on Audit will always be mentioned in most, if not all, cases involving disallowance cases made by COA. Okay? So ito yung pinaka-paulit-ulit na ginagamit ni Justice Mario V. Lopez, where in Madera, the court cited Section 43 of the Administrative Code of 1987, which states that every official or employee authorizing or making such payment or taking part therein, and every person receiving such payment shall be jointly and severally liable to the government for the full amount so paid or received. Section 38, Chapter 9, Book 1 of Administrative Code explains that such civil liability of the officer is grounded upon showing bad faith, malice, and gross negligence in the performance of their official duties. In this case, the COA auditor aptly observed that the PAGWAD board members, as well as the general manager and district and division manager, patently violated the clear directives of its own charter as amended and AO 103. By jurisprudence, the palpable disregard of laws, prevailing jurisprudence, and other applicable directives amounts to gross negligence, which betrays the presumption of good faith and regularity in the performance of official functions enjoyed by public officers. Okay, since kayo yung dapat alam nila, 'di ba, yung mga ganong mga issuances, and they should have been very vigilant in before making those allowances, 'di ba? That's why they were adjudged na hindi sila good faith. The presumption of good faith does not apply to them. Hence, the proper co that hence the COA proper correctly held Pagyo and Aguilar liable despite not being the recipient of the disallowed amounts. In the same vein, board members who granted various benefits unto themselves in contravention of the aforecited laws and issuances are solidarily liable to refund the unauthorized benefits that they receive. Okay, bakit tatanungin niyo, bakit saan napunta yung solution indemnity and unjust enrichment na part? So, in cases, in COA cases, okay, especially with the Madera versus Commission on Audit case, if you would read it in full text, dun nilay down yung principle na sa pag-refund ng mga disallowances, it is under the principle of solution indemnity and unjust enrichment. Okay, kasi nga hindi naman para sa kanila yung pera, so they were unjustly enriched. Okay, so yun yung isa sa mga yun yung doctrine doon sa Madera versus Commission versus Audit, which is part of this case. Okay, so yun. So here, Justice Mario P. Lopez taught us that about the um, how can the liberality of the rules cannot apply. Okay? Hindi siya mag-a-apply. Tuwing kailan siya mag-a-apply, at in this case, hindi dito din nag-apply yung liberality wherein the court strictly followed the prescriptive period, and also the court through Justice Mario B. Lopez explained that the local water districts are also within the ambit of the power of the president and as a GOCC, and therefore yung administrative issuance regarding issuance of allowances and other additional benefits should not apply to them kasi merong prohibition. Okay, and of course being the one who approve the payment, they are solidarily liable. Okay, the general manager and the board of directors for having disbursed an amount um, which is illegal for lack of legal basis. Okay, so Justice Mario V. Lopez also discussed in this case, Engineer Pagyo versus COA, the role of Commission on Audit. Okay, so extra na lang to. Justice Mario V. Lopez said that no less than a constitution vested COA as the guardian of public funds with enough latitude to determine, prevent, and disallow irregular, unnecessary, excessive, extravagant, and unconscionable expenditures of government fund. Only when COA acts without or in excess of jurisdiction or with grave abuse of discretion may the court grant a petition assailing the COA's action. There is grave abuse of discretion only when there is an evasion of the positive duty or a virtual refusal to perform a duty enjoined by law or to act in contemplation of the law, as when the judgment rendered is not based on law and evidence but on caprice, whim, and despotism. Okay, and also Justice Mario V. Lopez explained also the doctrine of immutability, given that this case has already lapsed into finality. Okay, Section 51 of PD 14445 Government Auditing Code of the Philippines states that a decision of the Commission or any auditor upon any matter within its jurisdiction, if not appealed in accordance with the COA rules of procedure, shall be final and executory. This decision becomes immutable and unalterable and may no longer be modified in any respect, even if the modification is meant to correct erroneous conclusion of facts and law. This doctrine of immutability is grounded upon the fundamental principles of public policy and sound practice, that at the risk of occasional error, the judgment of courts and quasi-judicial agency must become final at some definite date fixed by law. Thus, no grave abuse of discretion can be imputed against a COA dismissing the petitioner's petition for review being filed beyond reglementary period. So, dito lang, um, dinidiin lang ni Justice Mario V. Lopez na pag late ka na, the doctrine of immutability applies, okay, as per Section 51 of PD 1445. Of course, it is also applicable or ginagamit din natin itong doctrine na to when it comes to the general civil procedures as well. Okay? So, ayan, medyo boring, di ba? Yung case. Pero yun lang naman yung case ng engineer Pagyo versus COA. I hope this helps and happy aral.